SLATs, also known as spousal lifetime access trusts, are very popular right now for gifting purposes. Now, in a lot of cases, a married couple might create this type of trust and still engage their same investment advisor. And the investment advisor usually wouldn't serve as trustee here, but for those investment advisors who are engaged by the trustee, especially if a trustee is a spouse, they can run into pitfalls and encounter blind spots that may not be anticipated with this type of trust. And there's not much guidance out there on this unique type of trust when it comes to portfolio management, especially given the fact that the settlor of the trust is usually still living. But in this presentation, we'll parse out some of those unique aspects that should be addressed. I'm Griffin Bridgers, and this is 10 Minutes with Griffin. Today's episode 231, is skimming the surface of portfolio management for the SLAT. Now, it's important to note that I am not an investment advisor. I'm not a financial advisor. I didn't stay at a Holiday Inn Express last night, so I couldn't really dive into the nuances of this. Really, what I'm approaching this from is more of a trustee goal, a trustee fiduciary duty aspect, and also kind of the general themes and language that go into the SLAT itself. Now, as always, this presentation is not intended to substitute for legal or tax advice. It is provided for educational purposes only. And if you enjoy this episode or any episode in my series, and you'd like an in-person or virtual speaker for your firm, organization, or upcoming event, you can reach me at griffin.bridgers@gmail.com. Now, what is a SLAT? Well, Spousal Lifetime Access Trust, also known as a SLAT, is really a credit shelter trust that's set up during life. And if you don't know what a credit shelter trust I have a previous episode in the Common Estate Planning Trust series that dives into that. But the general theme is that one spouse creates and funds the trust, and the other is a beneficiary and maybe trustee as well. And typically you'll have children and descendants as beneficiaries as well, whose needs as beneficiaries are usually subordinated to those of the spouse. But regardless, the children and descendants would also be remainder beneficiaries of the trust itself. Now, there's one overarching goal of the SLAT, and that's to use one spouse's lifetime gift tax exclusion of up to $11.7 million in case it goes down. Now, a secondary common goal for funding lifetime trusts, which can create a conflict here because it typically has carryover language from prior use trust instruments, but which may not be the actual goal here, is the value freezing effect, which is the usual intent behind a lifetime gift of assets. Now, that goal may be secondary to the actual use of exclusion, which is worthy of its own series of discussions on that nobody has really called out that potential conflict of settlors' actual tax goals. And that addresses things from the transfer tax perspective, and the SLAT is almost always a grantor trust, not because of a swap power, but instead because any income and capital gains that are added to principal can be distributed to the settlor's spouse. So that pretty much makes this constantly a SLAT as long as the settlor's spouse, or constantly a grantor trust as long as the settlor's spouse is a beneficiary. It's hard to turn that off and create a non-grantor SLAT without terminating the spouse's beneficial interest, which again is a subject I've covered in the past. Now, fiduciary duties are tricky here. And I'm not implying that the investment advisor would be a fiduciary here, but it's important, depending on state law, to kind of check what the blind spots might be here. And I can't speak to this in full, and I can't speak to every state's laws, but based on the investment advisor's knowledge of trust investments and distributions, you could at least be pulled into a dispute, and there could be some spillover effect of trustee duties and fiduciary duties depending on how egregious the trustee's misconduct might be. And that's especially exacerbated in a situation where the spouse wears two hats as both trustee and beneficiary. And it's easy to think that the spouse as trustee will protect you as investment advisor, but it could actually make things worse because regardless of who the trustee is, there is a inherent conflict within the trust itself between the needs of the spouse as beneficiary and the needs of children and descendants as current and remainder beneficiaries as well. It can be hard to balance those conflicting interests within the SLAT itself. So long story short, what the investment advisor could end up with is this middle ground where typically as a fiduciary, not from a trustee perspective, but more from an investment advisor perspective, your duties typically extend only to a married couple. But in this case, you may end up having an expansion of those fiduciary duties where you're now managing assets for all remainder beneficiaries of the trust as well. So you have to take into account the needs of the children, and you can no longer look at a distribution horizon which could drain the entire trust at the expense of the children themselves. So the big question is, should you seek indemnification before proceeding? I think it's important to get local counsel to advise you on that and possibly examine whether that's worth doing based on your own compliance needs and based on the trust itself. Now, that aside, the general investment goal is just kind of spitballing, kind of balance, three buckets. One is the current needs of the spouse. The other might be the current contingent needs of children and descendants if they're current beneficiaries. And then also the future needs of children and descendants as remainder beneficiaries. Now, a lot of people tend to think that cutting out children and descendants as current beneficiaries may ease the investment goals and ease the potential for conflict between spouse and children, but that could actually exacerbate it depending on the circumstance. And that's its own separate subject in and of itself as well. But really the common goal here is that you end up having to balance producing income for the spouse's needs and also maximizing capital appreciation for the future needs of the remainder beneficiaries. Divorce can also be a factor depending on whether a spouse is a beneficiary after the divorce as well. And that's beyond the scope of this episode, but especially in a situation where the spouse maintains a beneficial interest, that can really exacerbate that potential conflict, and it's important not to pick sides before or after that happens and balance all of these conflicting needs within the trust itself. Now, portfolio rebalancing is possible, especially because the SLAT is a grantor trust during the settlor's life. But you can't rely on a future step-up in basis for the assets in the SLAT at the death of the settlor or the death of the spouse unless there is a Q-tip election, which a Q-tippable SLAT is a subject for another time as well. Now, since the needs of beneficiaries can create conflicts, as an investment advisor, you can find yourself thrust in the middle of these conflicts. And if there is ever a legal dispute down the road, you may have to show or substantiate how you took into account those conflicts and the numbers behind them and how you balance those different needs. And this isn't a complicated thing. I think even doing the bare minimum to say, hey, I acknowledged these and invested and distributed in a way that balanced all of those conflicts can help. Now, in that case, you might want to look at maybe bifurcating the trust into different investment accounts based on which beneficiaries' needs are being taken into account, because that can help if the distributions are ever challenged and you find yourself involved in a dispute. Whether or not you're an actual party to the dispute, you may just be doing discovery to provide investment account statements to the beneficiaries themselves. But this can also be complicated in a situation where the SLAT is also funded with illiquid assets that you don't manage. Now, that can really send us down a rabbit hole. So what we're really going to do here is assume a scenario where maybe the entire SLAT portfolio is comprised of investment securities. So what you might need to do is start with the spouse's life expectancy and work backwards using actuarial calculations to, one, look at an investment for income based on the present value of maybe a life estate for the spouse, and how do you maximize that? And then also, maybe after that, look at the maximum potential needs of the spouse and descendants on a year-over-year basis. So this isn't set in stone, this can vary. And with this second portfolio, you may have to invest for a mix of income and capital appreciation, and also consider on a year-over-year basis other resources and income of the beneficiaries, depending on what the trust terms say. And then the balance after those two buckets in a third portfolio can be invested to maximize capital appreciation for the remainder beneficiaries. Now, it's important to note, I mentioned rebalancing earlier, and you may have to rebalance not just within the sub-portfolios themselves here, but also maybe between sub-portfolios, depending on the changes in circumstances, which is why I emphasize that bucket number 2, the second portfolio, may have to be recalculated on a year-over-year basis in terms of what assets are there. And this rebalancing is easy, again, from an income tax perspective, because as I mentioned, this is a grantor trust. But either way, it's helpful to kind of maybe bifurcate things like this, not in terms of trust shares at an administrative level, but more based on sub-portfolios and sub-investment accounts within the trust itself. Now, it's important to note here that the settlor is not a beneficiary. So if you're used to investment planning and distribution planning for the married couple themselves, that gets cut off the minute you start managing the portfolio for the SLAT. You can't use the settlor's needs in projecting distributions because you can't make distributions to the settlor, and the trustee shouldn't be making distributions for the settlor's needs anyway, because that can breach the primary goal of this trust, which is transfer tax savings. Now, that aside, you may want to look at a portfolio or a scenario where you limit the distributions to the spouse to income only, really just for their current disposable needs, because any distribution of income or principal that's not used by the spouse essentially reintroduces assets to the spouse's potential taxable estate, which can waste the gift and GST tax exemptions which were used to fund this trust up front. So that's why it's important to not take money out until it's actually needed. And if there's a need like a house or something, or some large depreciable or appreciating asset, you may want to consider distributions for depreciable assets, but titling within the trust itself any appreciating assets like real estate. You might also have to dig into the trust language, and I mentioned earlier a good idea might be to have your own counsel, whether in-house for compliance purposes or outside to consider the trust language and your duties as an investment advisor. But the problem is that trust language is often form language that can give conflicting goals, because within the SLAT itself, the language hasn't been well developed. So you might see conflicting language like, one, maybe the trustee can consider the needs of the spouse over the needs of settlor's descendants, which might also run into a few sentences later that trustees should take into account the resources and income of a beneficiary, which can include the spouse, or other trusts in making distributions. So that can raise all sorts of issues as to whether you have the green light or a yellow light or even a red light in making distributions to a spouse. Now, finally, a lot of irrevocable trusts and the forms, as I mentioned, have conflicting language because they're drafted for the traditional goal of capital appreciation and freezing the value within the trust itself. So the distribution language and the common themes of distributions take that into account. But where the primary tax goal for the first time is now use of exclusion over this goal of appreciation, that may not be as articulated within the trust itself, depending on the form used. Now, it may be important to clarify that while the settlor is still around, because if the primary goal can be articulated as just simply using exclusion, it may lower some of the liability for investment risk, but increase the liability exposure for actual distributions to the spouse. So lots of things to think about when it comes to a SLAT, and my goal here is not to scare you off, but really just to kind of say, hey, like an attorney, you're always creating a paper trail and covering yourself, and it might be helpful to do so when you're managing the investments for any trust, but especially for a SLAT. As always, if you have questions or topic suggestions, you can email those to me at griffin.bridgers@gmail.com. As a reminder, I cannot give tax or legal advice in response to your questions, so please limit questions to the material itself. Thank you again for listening to this episode of 10 Minutes with Griffin, and I look forward to seeing you in the next one.